Good evening, everyone. Zachary Epps, co-chair of the policy committee, officially calling it to order tonight. And we'll start with the roll call. I'll start to my left.
Do you have an agenda, Adrian?
Good name, Felton.
Agenda.
Robin Murphy,
Agenda.
present.
Mia Blitz, present. Jennifer Roman, present. Mia Montana, present.
Williams present.
And
Pamela Henry present.
And just in case, for the audio, we do have one virtual member, Pamela Henry, just checking as well. All right, we'll move forward for consideration of the minutes from our last meeting in April 25th, I believe. I'll take a vote.
Aye.
I'll hand it over to administration for our agenda.
We're gonna start with old business.
Yeah, we could start with old business. Good evening, everyone. It's good to see everyone. I have Christina Gallagher with me today. She is our in-house Title IX expert. So we're looking at some of the Title IX policies. So I wanted to bring her along in case there were any questions. We'll get to that material in a moment, but we can start with old business. We have policy 227, which is controlled substances. Policy, like the next several were looked at last school year. For all three of the items for that matter, that are on the old business section of the agenda, no changes have been made since the board adopted these for first reading, and they're just coming back for a second look before they move forward to final adoption. So if there's any questions, I'm happy to address them. All right, we'll go on to 233.
Quick question.
Yeah.
And I wasn't here in April, so maybe ask. But just out of curiosity, just in really aligning, there's some language in the AR on the student assistance program, and then in the policy itself, purpose district wants to prevent controlled substances. But is there something that we can add? This isn't substantive either, but is there something that we can add just to kind of align those two? That because there's obviously there's some requirements that the district has to notify law enforcement, and there's a pathway for that that's described. And so because we have a holistic approach to this, is there a way to represent that in the purpose as well?
Purpose statement. So the board recognizes that the abuse of controlled substances. All right, so let's move on to the next one, which is 233, suspension and expulsion. Any questions there?
Question from the board.
One of the other things just to note while we're on the suspension and expulsion policy, the handbooks were updated comprehensively this summer. I can see the smile on Jen's face. That's been something that for 2 or 3 years now we've been saying we were going to do, and finally with the combination of Dr. Scriven, Dr. Feely, and Mrs. Savage came together, and we assembled a team of principals and central office administrators, some folks from my office, and we put together standard handbooks. I don't know that we have done, I know we did the elementary level, Dr. Scriven, and we were working on secondary. If they're not done, they're almost done. So
Almost done. Not quite there, but they're almost there.
Okay, perfect. And the goal is to move towards embedding links in the documents so that as the policies change, therefore the references in the handbook change.
Great.
So that's an exciting upgrade for this school year. Anything else on 233? Right, then we can go to 260, makeup work after absence. There were no real changes to this. We simply added a paragraph at the end here that talked about if a student's IEP or 504 plan required certain accommodations for making up work after extensive periods of absence, that support would be provided. This had come to us because of, this was a routine review policy. All right, so if there's nothing else, we'll go into new business. We have a couple of quick ones here. Policy 807, opening exercises, flag displays, moment of silence. There was a change. It was Act 25 of 2024, new piece of state legislation that requires a moment of silence on the anniversary of September 11th. That law went into effect in June. So we simply added that language to this policy. Nothing else changed. Oh, wait, I'm sorry. This is a new policy here. This was a gap actually that we identified in the manual. We went to add the language about a moment of silence on the anniversary of September 11th and then realized that this policy 807 was missing. This policy essentially states that flags fly as required by law around the district. There's a moment of silence on the anniversary of September 11th. And then there's language in here about if students want to decline to recite the Pledge of Allegiance, they could certainly do that, and that they just have to, not interfere with others who are participating. Years ago, there used to be language that would say principals should call home if a student declined to say the pledge or anything like that. All of that language is out. Students have that choice, yes or no, but if they choose not to participate, you just can't interfere with those that are participating. Any questions on 807, which will be a new policy?
Not a question, just a comment.
Yep.
Inclement, there's a space there. So just a.
In Clement.
Oh, I thought that would be. Okay,
I've had the same thought about 100 times.
I have to look at that. That is.
Clement weather would mean clear weather.
Yeah.
In good weather, the flag should fly.
I gotta tuck that one.
Wow.
Tuck that one into my.
Right?
Yeah.
It got me a number of times.
That's great. Thank you for the clarity. I learned something today.
All right, policy 803, school calendar. Most of you will probably remember, I remember from Zachary's legislative report, the state legislature added that you could meet the minimum instructional requirements. It's not just 180 days, but now you can meet the requirement with minimum number of instructional hours. So we changed the school calendar policy to state that the calendar has to consist of the days or the required hours. There's also an AR with this policy that's been in effect, and I don't believe it has changed. Questions or comments on 803?
Actually, I do have a quick question, probably mainly for Adrian. Adrian, in the negotiations with CEA, I know there was some conversation around when we talk about the school calendar and well, that's it. Well, I may actually kind of answer my own question as it pertains to changing things around with the proposed scheduling changes. Does that policy does that conflict with what we're doing in the policy here?
No, their concern was they're required.
Just, yeah.
Oh,
Point of clarity. Yeah, sorry, go ahead.
No, I think I'm just like.
no, she's talking about in our current CEA contract.
Right.
Okay.
I
Not-
I wanted to, yeah,
Okay.
there was a lot of conversation and interest
Oh,
with the board. I just happened to be one that
Yeah.
maybe be closest.
in the current CEA contract, the concern was the the first calendar had less than 180 days for the students,
Mm-hmm.
as we were complying with the 900 hours. However, in CEA's contract, it required us to have 180 days for students. So that was their concern, that we had less student days than they had in their contract.
Right.
So we should be fine with this language.
Okay.
And then I'm thinking, was it 180 or 181?
Somehow I thought it was 181, but I'm
Yeah, I
not.
think you're right. It was 181 in their contract, but this has a minimum of 180, so we're fine.
Okay. All right.
Let's jump to 804. I know I'm skipping over 801. We'll come back to that, but 804 did not have any substantive change other than that the legal references were moved from the body of the policy down to the legal reference section. But since we were looking at the calendar policy and the school day policy had the same review date, I thought it would just be a good opportunity to bring them forward together to look at it, but there are no changes here. So if there's any questions about 804, otherwise we'll move it along and it'll just get a new last revised date. All right, we'll go to 801, public access to district records. This policy we brought under review. There has been some guidance from the Office of Open Records, and there's also been some Office of Open Records decisions that have come out regarding how to handle anonymous right-to-know requests that have been coming in. And Cheltenham has actually been one of the districts statewide that's been affected by these anonymous requests. And what we're seeing is that there are public interest requesters out there, I'll call them, those that want every record that talks about the word transgender, that talks about flying pride flags, right? Any and all records that use these words. And they're being requested by folks that do not live in the district, do not live anywhere around here. You can you can do some internet research about these folks and you can clearly see that they're connected with either political or social organizations. But what's happening is they're using AI platforms now to generate right-to-know requests, and they are generating thousands of requests. So we had a period of time here where I want to say within the same week between the high school and the middle school, we must have received 60 right-to-know requests from this same entity asking for your policy on pride flags, your policy on transgender athletes, every record that ever refers to the Holocaust, whatever the case may be. They're not seeking records that are actual transactions of the district. They're just seeking records that use certain words. And so the Commonwealth has come out with some guidance that has essentially said when there are anonymous requests, you don't necessarily have to answer them, because in order to be entitled to make a request, you actually have to be able to show that you are a person that is a legal resident of the United States. You can't just be an unknown person or an unknown electronic platform that's generating these things. We also updated during the last school year, the board may recall, the open records officer was changed from Dr. Scriven's assistant to the director of business services. So the compliance with right to know now falls within the business office as opposed to the superintendent's office. And it's more common in school districts that it be a business office function. Those were the two big changes. The other changes were relatively minor. questions on right to know process? Most of that process is dictated by state law, and we follow the state law. All right. Let's turn to 103. 103 and 104.
Was there anything on the AR
Thank you.
for 801?
Let's check. That's right. We didn't touch the AR. The AR was just the fee schedule for records. All right, so with 103, so we've got 3 items left, 103, 104, and 348. Those are all the Title IX related policies. So earlier this summer, the new Title IX regulations went into effect, and they change, they make some changes to the ways in which the district is required to respond to complaints that would fall under Title IX. And you've probably heard a lot about the Title IX changes, right, in the news and in different legal updates. Although from a practical standpoint, the regulations haven't changed all that much. And the reason I say that is because, for example, one of the things that the regulations do is they now state that when you are thinking about Title IX and the concept of sex under Title IX, that also includes gender identity, gender expression. All of those things were already things that were incorporated. We were already recognizing those things in our non-discrimination policies. So if someone came forward to us prior to August, when the new regulations went into effect, and said, I'm being harassed based on my gender identity, our response would not be, well, that's not covered under Title IX, we don't address that. We were already proactively ahead of the regulations, so to speak. There were some changes that we did add with respect to pregnancy, childbirth, and pregnancy-related conditions, which are also now recognized as a component of sex discrimination and sex harassment. So those items were added. We also now have a new grievance process. So when someone comes forward and wants to make a complaint under Title IX, there's a grievance process that gets followed. And that process talks about what are the rights of the complainant, what are the rights of the respondent, who is the person that conducts the investigation, what rights do the parties have during that investigation to ask questions, to review evidence. There are not a tremendous number of changes to that process. The biggest change is that under the old regulations, we needed to have 3 separate individuals participate in the process. Someone would investigate the matter. Someone would be designated as a decision maker who would review the investigation report and make a decision. And then someone would be an appeals officer, where if there was an appeal, that person would hear the appeal. For K-12 entities under the new regulations, you can now use a single person to handle that process. And that's not unlike most discipline investigations, where you might have a principal, for example, investigate student conduct, and then based on their findings determine, was there a violation of our policy? And if so, what is the consequence that would be imposed? Certainly there's always, there's always an opportunity to quote appeal to a higher authority, but now it makes, by being able to use one single person as opposed to 3 individual folks, it actually, in my mind, will speed up the process, and there will be more continuity between the stages of the process, as opposed to one person's going to do this, now someone else is going to do this, and now someone else is going to do this.
And can the Title IX coordinator also be the investigator now?
Yes.
And that is helpful because in Cheltenham, given that your HR director is the Title IX coordinator, the HR director is trained generally in investigations that involve adults, right? So those are the general changes with the law. We also changed in the regulation, and I think this is a change that makes sense. obviously, Director of HR is the Title IX coordinator. In the past iteration of our policies, the athletic director was the assistant Title IX coordinator. The proposal is to change that to the Director of Student Services. The thought being that, frankly, I think athletic director should be focusing on athletics, but the athletic director also doesn't really touch the elementary schools as much and doesn't have as much visibility there. And what we are seeing, and one of the findings out of the new Title IX regulations, is that thinking about Title IX is becoming more and more important even at the elementary level. And a lot of things that we have to think about from a Title IX perspective are with some of our youngest learners. And so having the Director of Student Services that can look at things from a K-12 realm, we think is an upgrade to the policy.
And we had a few at the kindergarten level.
Oh, wow.
And it doesn't mean that just because we're reviewing something from a Title IX lens at the elementary level means that there's a Title IX violation. But one of the things that we have to do when there is an allegation of sex-based harassment or discrimination, even when it's with young children, we at least have to notify families that they have an option to pursue this Title IX grievance process. We've been, we have trained a number of central office administrators and building administrators in the past on the prior regulations. And I think we now have training scheduled for September, right?
Yes.
For, under the new regulations. The good thing is this policy will have gone through our first reading, so we'll be able to refer to this at least as the policy that's likely to be in place moving forward. Any questions on Title IX, or those are the, did I miss anything in terms of the big changes?
Nothing in terms of the policy itself. There were a couple areas though in the policy that I noticed where sexual was changed to sex harassment, but if there were some that were missing. So I don't know if that was, that was just an oversight or intentional, but I wanted to call it out. So when the policy gets,
Yeah, Ms. Henry, can you point to one, and then I'll know what I'm.
yeah, scroll down to the next paragraph. Was it here? Wait a minute.
And if you can't find it now, you can always send it to me after. That's fine too.
All right, I'll send it to you. I know exactly where it was. I didn't write it, and then you went to the other policy. I'm like, darn, I lost it, but I'll find it because I was looking directly at it.
Yeah, perfect. Thank you.
Okay, I'll send it to you, Ed. No problem.
I think there's a typo in
Yep.
the ARs,
Yep.
so 103 and 104.
Okay.
The steps, are step 1 reporting, step 2 assignment of investigator. I think it should then be step 3 investigation.
Yes.
And then it's sort of there. And I think, I don't know, this is what I noticed. I don't know if this is what you're talking about, Kim, but in the policy 103 and 104 underneath guidelines where 103, we talk about, sexual orientation, gender identity, gender expression. Then 104, I thought I noticed. Oh, genetic information. Yeah, 104 contains genetic information. And 103 doesn't. I don't know. Difference.
Yeah.
The inclusion, I think we added genetic information. That's another protected class specifically for employment. So you can't discriminate against someone based on their genetic information or potentially medical background that would necessarily apply in that student context. I think there may have been another ad, and that was kind of while we're looking at this policy, there were some other recommended changes to make sure that we have all of the protected classifications in each policy.
Thank you. And, oh, I know, the other thing I just have a question about is also the AR. I didn't understand the heading, where it says non-Title IX discrimination.
Yeah, so that'll become relevant in a moment when we talk about 348, which is the employee harassment policy. We're proposing to get rid of 348 because any type of harassment on the basis of race, on the basis of age, on the basis of sex, is all covered now under 103 and 104, but only sex-based harassment is the Title IX, has a Title IX impact. So if you're being harassed on the basis of race or age or any other protected class, that's non-Title IX harassment, and there's a procedure that outlines how we would address that. The goal here was, if you think about it conceptually, if someone feels like they are being treated in a way that they shouldn't be because of a protected class, because of a membership in a protected class, we shouldn't have all different kinds of policies that figure out which policy do we have to follow and what process applies. It's very confusing. So now we're in a position to be able to say, if you feel like you're being treated in a way that's not right, here's our policy. Student policy 103, adult policy 104. Eventually, you may be seeing a repeal of the 248 policy, which is the student harassment policy. The reason we haven't recommended that yet is because currently our bullying policy and our harassment policy are combined, and we need to pull out the bullying piece before we just repeal 248. But that will be coming once we get 103 and 104 in place. We will have a second set of Title IX policy updates where we will probably be looking at the pregnant students policy, the gender expansive policy, the bullying and harassment policy, all of those other policies that sort of have a Title IX impact via like a cross-reference. And we just want to make sure that the language between 103 and 104 is standard with all of those other policies. Does that help conceptually?
That does help conceptually. But I'm still confused
Yeah.
because with the kind of non-Title IX discrimination and harassment in place, that seems to me to suggest that there is a Title IX discrimination and harassment complaint procedure.
Yes,
And
that's the grievance process, which gets posted on the district website. It is not incorporated. What we probably should do, and what we've done in prior versions of this document, are we put a hyperlink, because we're required on our website to post a non-discrimination notice and the identity of our Title IX coordinator on that landing page. And I can see if I can pull it up here. We have a whole page on Title IX here. Our grievance process is here.
Okay.
This website should probably be hyperlinked in 103. And that's something that we can do.
Okay, thank you. Yeah, something to sort of delineate the fact that.
Yep.
Yeah, something to make sure that there actually are two separate processes involved, if it's Title IX or not Title IX. Because this talks a lot about Title IX, and then we get to a heading that says not Title IX.
Correct. Yep. So we will update this this page and then provide a hyperlink into the AR. That's a good suggestion. Thank you, Jim. And the same will apply in both 103 and 104. Any other questions on 103, 104? Any questions?
Another random
Yeah.
question, and I know, I'm sure there's some legal reason behind that, it's maybe case law, I don't know.
Question I have, I bet.
Yeah, it's, why don't people get to see the findings, like the, the final report, the investigation?
So they get the,
Like in a-
they get the outcome,
Okay,
right? What they don't necessarily get is the investigator's notes of everything that every single witness said in the process.
Yeah, okay, that makes sense. That's,
But they do get to understand what were the results of the findings, or what were the results of the investigation. And usually a short statement that supports so there was or was not a finding of a Title IX violation because of.
okay. All right, this is where it says, oh yeah, parties are not entitled to a copy of the written decision. I figured there had to be some reason why
Are you in 103
I'm in 104.
AR? All right, let's look at the language.
To the very end of the procedure. I think it says it somewhere else.
Because they do get written notification of,
Yeah, it says they can provide
Where
a
at?
summary.
what step, Jane?
3. Very end. Oh, down. Oh, I'm sorry. Number 3 under step 4. Under the appeal. Under what? The appeal.
Under
procedure.
appeal. Keep going down.
There you go. Yeah, it's right above the complaint.
Appeals officer shall decide the appeal and provide a written decision to the coordinator. Shall provide a summary. They are entitled to a copy of the written decision. They're not entitled to the investigation report, right?
Yeah, and I think the thinking there was the same thing. They wouldn't be, if there were a complete appeal report, they wouldn't be entitled to that, but they would get the outcome.
Right.
Similar to the investigation.
We can clean that up.
Okay.
I think it's meant to say of the report, not that
Okay.
you do get a written decision of the outcome. Yes.
Okay, but all right, thank you. I was like, huh, that's interesting. There
Yeah.
must be some weird reason.
No, that's a good point. And we will be, one of the other changes is that to the Title IX regulations is that all staff need to be now undergo Title IX training. So that's everyone. Most likely what that will look like if we do follow the same path that most school districts are following, there's a training, an online training that Vector will host. But then there will be more extensive training. For example, Christina's coming in September to do like a 90-minute training with building administrators and central office administrators who may have to play a role in the grievance process. But the very high level Vector training is good for the rank and file staff, where the most important thing is to let them know the type of conduct that they should be looking for and who to report to. They don't necessarily need to know the ins and outs of the investigation process because they don't play a role in that.
Yeah, so we're including all of the principals and the vice principals in the training. As well as central office staff on the ed side.
Yeah, 348, if there's no other questions on 103 or 104, it's just a repeal. You'll see that this 4-step process for investigating complaints of harassment is now embedded in that 104 AR. And remember that the scope of 104 is all of the protected classes that were listed at the beginning, not just sex-based Title IX harassment.
Covers our, we're going to put, that covers our new business, so as we move forward for first read. You mentioned something about timing. You don't come back until October. Is something that around the Title IX or
I think that the October date and then the early November adoption date is fine. The new regulations are in effect. we will likely post the new grievance process. That's the other good thing about the grievance process living on the website is we can get that posted. We've already coordinated with Adrian's office. We have training on the books for the folks that need to be trained. So I think it's natural that the policy approvals follow. I mean, it takes a few months. So I think as long as we get it done by November, it's fine.
Any other comments from the group of us? Or we entertain a motion? Well,
Thanks, everyone.